Good morning and welcome to the Maryland Public Service Commission. We are on the record in docket number RM70. This is with respect to competitive billing supply. By notice issued on January 5th, 2022, this has been noticed as the time and place for the Commission to consider final adoption of the proposed regulations to its standard for consolidated billing by retail energy suppliers. As those in this room are well familiar, the Electric Customer Choice and Competition Act of 1999 required by statute that this commission promulgate regulations with respect to competitive billing. It sat dormant for the better part of two decades, but in 2017, the petition that was filed by Nrg Energy and other petitioners prompted this commission to initiate rulemaking proceedings. In 2019, the Commission, by order, authorized supplier consolidated billing. We spent many hours in 2020 and 2021 with respect to hearings on competitive supply, and the Commission ultimately, on March 10th of 2001, adopted proposed regulations to the Code of Maryland Regulations to implement supplier consolidated billing. That vote at the time was 4-1. On December, Mr. Kane from WGL. If we could, there we go. Thank you, Mr. Kane. On December 3rd and December 17th of 2021, the proposed regulations were published in the Maryland Register for notice and comment by January 17th, 2022. 5 parties took that opportunity to file comments, including the Energy Supplier Reform Coalition, GEDCO, Maryland Energy Savers, the aforementioned petitioners led by Nrg Energy, and the Joint Maryland Utilities, consisting of 5 large investor-owned utilities in Maryland. The commissioners have reviewed these comments, which both support and oppose the proposed regulations. At this time, does any party at this hearing session wish to be heard? And I may not be able to see you, so if you'd like to speak, you may do so after announcing your name.
Good morning, Your Honor. This is Brian Green. Can everyone see me and hear me okay?
Good morning, Mr. Green. There you are. Yes, I can see you now.
Yes, thank you. I just wanted to briefly say, if I could, on behalf of NRG and the other suppliers, we filed comments on January 3rd and January 18th in support of the proposed published regulations. And our position is that the regulations reasonably balance the competing stakeholder interests and create a game plan for a viable, successful SCB program going forward. The comments that we reviewed generally focus on either cost recovery, which is, in our view, not before the Commission today. It's not part of the regulations, and the Commission indicated in its recent order number 90046 in mid-January that it would address that the utilities were to establish a regulatory asset and the costs would be looked at later. And the working group, by the way, is my understanding is going to be considering cost recovery issues for the Commission's consideration of the later date. So our view is that it's not before the issue, before the Commission today. The other items in the non-utility comments really focused on an attack on retail choice in general, which also this is not really the docket for that, respectfully. The joint utilities had one issue, the payment posting issue and the treatment of payment posting in the regulations. They also mentioned bundling. They support the bundling language. I think this is evidence that everyone won some and lost some in these rules. When you look at it from an overall holistic picture, it provides a good balance of everyone's very, very competing interests, including my clients. So we support the regulations as published, and we hope that they get approved as final today.
Thank you, Mr. Green. Are there any other persons that wish to speak today? Seeing none, do commissioners have any comments that they would like to make? I would note, before I recognize Commissioner O'Donnell, I would note that the cost recovery issues that Mr. Green has just mentioned, that was an accurate statement, that they are not being addressed in the rules that are currently before the commission today, but will be addressed at a later time, as the commission stated in an order issued about 2 weeks ago. Commissioner O'Donnell.
Mr. Chairman, just as a matter of process, I know from my days in the legislature, we were always told, well, you can't explain your vote until you vote, right? So I could explain it now, or I could wait until we actually cast our votes, and then I'll explain my vote.
Thank you, Commissioner. I would suggest waiting until the vote. Okay, at this time, as I noted, it has taken more than 20 years for the commission to get to a point where it has been required by law to issue regulations with respect to competitive billing, and we are here today. I would make a motion that the commission finally adopt the Supplier Consolidated Billing Regulations contained in Title 20, Subtitle 51, 53, 54, and 59, as published in the Maryland Register, subject to non-substantive changes necessary to conform to COMAR drafting requirements. The vote begins with Commissioner Herman.
Thank you, Mr. Chairman. My vote is no, because the purchase of receivables issue, I think that it properly should remain the same as with utility consolidated billing, as I discussed in my prior vote. So my vote is no.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
I vote aye, Mr. Chairman, but it's not without some trepidation that I do vote aye. I've lost more than a few policy decisions during the course of this rulemaking process, and I do have some resident concerns, but I won't use this opportunity to try to block these regulations. I don't think that's my role. And so I cast a vote aye with a hopeful heart that some of the concerns I had are not realized, and we move forward with this in Maryland. Thank you.
Commissioner Richard.
I vote aye.
Thank you. As Commissioner O'Donnell just stated, and as Commissioner Linton stated when we last voted on the proposed regulations on March 10th of last year, not every party got what they wanted with respect to these very, very complicated regulations. The fact that it took the better part of a year to publish these regulations in multiple parts in the Maryland Register reflected that. I am hopeful that any of the concerns that commissioners shared along the way will be addressed, and that some of them do not come to fruition. The commission can always change regulations in the future if the program isn't working as intended. With that, I vote aye. The motion is approved. The final regulations will be published in the Maryland Register forthwith. With no other matters before this commission, this rulemaking session is now adjourned. Thank you.